Welcome to Aging Insight with your host, John Ross and Lisa Schollmeyer. This program is made possible by
Welcome to Aging Insight. I am Lisa Schollmeyer and I am here with John Ross, and you're tuned in to another weekly episode of the Aging Insight program where we discuss all sorts of issues that impact seniors, retirees, near retirees, and frankly, everybody else.
Yeah, that's about right. Yeah, people have often asked me, how old do you need to be to get the advice of an elder law attorney, and my response is always 18.
Yeah, that's right. And we've talked about different programs about special documents for college students and planning for disabled children. So really, I would say it's pretty much everybody could stand some advice from Aging Insight.
Absolutely. Well, and that's because people have concerns. They don't want to go to a nursing home if they can avoid it. They don't want to become a burden on their friends and family, and they don't want to go broke.
Right. They want to protect those assets from things like disability, their own death or death of a beneficiary or heir, from debts and bankruptcy of themselves or, their descendants and heirs. So there's a
divorce.
Divorce, yeah, big one.
Yeah,
so.
If you look back historically, and you look at a person's assets, and you go back, say, 40 years, and you're looking at a retiree of 40 years ago, that retiree would have a home that was paid for.
Yes.
They would have a car or two, their personal property. They would have Social Security benefits coming in, and then they would have a company pension.
That's right, a defined benefit pension, which was the kind of pension that you worked for however long for the company, and when you retired, you got a monthly check based on their formula calculations, and that check was going to roll in for a lifetime.
That's right. And so for the most part, any other savings they had would just be regular old savings. They might put a little in some CDs, or they might have some stocks and bonds, but just regular old savings. And of course, those companies that offered those pensions, they never really expected people to live quite so long.
That's right. So, these days, most folks don't have the availability of that company pension or that defined benefit plan, and they have to, retirees these days or employees need to be thinking about saving for their own retirement and, depending on themselves. And some of the most popular vehicles to do that with are 401k plans that maybe a company contributes a certain amount to that plan on behalf of the employee, but the employee is really contributing for themselves.
That's right. 403b plans, which would be typically you see these with teachers or other state employees, but predominantly teachers. But it's the same concept where the state is putting in some funds. You might be able to put in some of your own funds as well, but those are your dollars. And whether it's a 401k, whether it's a 403b, or some of the other, there's several other of those designations, or whether you're just putting some money back in IRAs,
right,
so that you can take a deduction now, let that money grow tax-free, and then eventually be able to take it out.
Right. So an IRA, or an individual retirement account, is a very popular savings tool for employees and business owners. And, so a lot of folks these days, we're getting to the point where IRA accounts, where either you've saved through an IRA, or perhaps you rolled over your 401k from your company when you retired and you put it into your IRA. These accounts are called qualified accounts, and these IRA type accounts are constitute a large percentage of retirement savings that folks have in the United States today, and they also constitute a large percentage of many retirees' overall asset picture. So, John, we talked about that 40 years ago, a retiree would often have a home, a car, some personal property, and that pension plan, and maybe a bit of savings. Well, now what we see is that home, car, and a sizable IRA account.
Right. It's not uncommon for me to be visiting with clients who their single largest asset is that IRA or company 401k account, and that may be more valuable than their home by a long shot in some cases. Especially with some of these surrounding companies have very good 401k plans, and they do very significant matches, and so it's not uncommon for people to have in some cases hundreds of thousands of dollars in those IRAs, which are great vehicles in the sense that all that money grew tax-free. But when you get to a certain age, you got to start pulling some of that money back out.
That's right. Those required minimum distributions that you must take when you reach age 70 and a half of your own IRA. And of course, John, the reason for this is the tax man would like to get a bite at some point.
That's right. And so, yeah, all of this money has grown tax-free during this time frame, and the IRS wants to get paid, but they say, well, when you turn 70 and a half, you're going to have to start taking some money out of that IRA, and we're going to tax you on that money as if you just had gone out and gotten a job and earned those dollars. And that's all fine and dandy. We get the idea that it is grown tax-free and things like that. So that usually is not necessarily the problem. The problem comes when we're talking about, that's your retirement account, but so often there's still a lot of money left in those retirement accounts at death. And dealing with an IRA or 401k or other qualified accounts at death is a whole nother ballgame.
Right. So, it took us quite a while to build up to the fact that today we want to talk about what to do with those IRA accounts and how to structure those accounts so that they pass at your death to your beneficiaries and heirs in a protected way, and a way that you would like to see that money pass on. John, we can't all plan to go broke. The old joke of you want to bounce your last check and take your last breath at the same time. Folks just don't do it that way because they don't want to run out of money. So a lot of times there are significant assets left in those IRAs. So when we come back from the break, we're going to talk about how to deal with those for the benefit of your heirs and other beneficiaries.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana, and there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioner still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
The Wadley Senior Clinic has been such a blessing for our family. Because they specialize in geriatric care, they take the time to really focus on Dad's needs. Their exam rooms are specially designed for seniors, and they offer lab and x-ray on site. With monthly educational programs on health and wellness of the mind and body, our healthcare questions get answered. Best of all, they accept Dad's Medicare benefits. See what the Wadley Senior Clinic can do for you. Wadley Senior Clinic, where healthy relationships begin.
Welcome back to Aging Insight, everybody. I'm your host, John Ross, here with Lisa Schulmeyer. And we opened up the program talking about individual retirement accounts, or IRAs, or other qualified accounts like 401k and 403bs. Accounts where you put money in, it grew tax-free, and then when you retire, you take money out of it, and then when you take it out, it's taxable. But so often what we are seeing now is that people have put so much into those IRAs, and when they needed money throughout their retirement years, they spent other things,
Right.
not wanting to have to pay the taxes when that money comes out. And so they end up leaving behind these IRAs, these large IRAs, which then can go to, maybe it goes to a surviving spouse, maybe it goes to their kids. But here's where the problem lies. We talk about when, so often people fail to plan for the worst case scenario and instead plan for the best case scenario. You want to plan for the worst and hope for the best. And yet people, maybe they've got 3 kids, they've got this IRA, and so they say, well, I just want to leave it to my 3 perfectly healthy, financially stable, well-married adult children. And that sounds like a wonderful, wonderful plan. Lisa, doesn't happen that way, though.
No, it really doesn't. When you were describing those well-married, financially stable, adult children, I thought, who are you talking about?
Right, that's exactly
I don't
right.
know those people.
Yeah, because you've got so many different issues. You might have a child who has financial trouble either before you die or at some point in time after your death. Marital trouble that leads to divorce, either while at the time of your death or sometime after. Bankruptcy, lawsuits, even the death of that child, whose share then lands in the hands of minor children,
Right.
who cannot manage it for themselves. So lots of different issues. We call these the 4 Ds: death, divorce, disability, and debt. And you should be planning for regardless of your assets.
Right.
The problem is if everything you've got in is in IRAs, or that's a significant portion of your retirement, then protecting your beneficiaries from those 4 Ds gets a lot trickier.
That's right, it does, because IRAs are special assets in the view of the Internal Revenue Service, and so there are lots of rules about how you can pass IRAs down to your heirs and beneficiaries. And frankly, a lot of times you're opening an IRA and you may be dealing with a customer service representative at a financial institution, or maybe you're dealing with a young financial advisor, and there's a form and it says, if something happens to you, who do you want to get your IRA and in what percentages? And it's easy to write down child 1, child 2, child 3 and write 33% next to each name, and boom, you've taken care of dispersing your IRA at your death. But what you haven't taken care of is anticipating the 4 Ds of that debt, divorce, disability, or death of one of those beneficiaries. And so you may have really blown the legacy and protection you were trying to get for those children.
That's right. So oftentimes when we're looking at protecting these beneficiaries, one of the things that we'll want to do is, instead of leaving assets outright to a beneficiary, we'll want to set it up so that it goes into separate trusts for each beneficiary. So for example, I might, if I've got 3 kids, I might say that at my death, I want my estate divided into 3 equal shares, but each one of those shares will be held in trust for the benefit of that child. If I structure this thing correctly, it becomes what's called a spendthrift trust. And the benefit of a spendthrift trust is that the assets, even though they're available for me or for that child, if they're available for that child, they're still not reachable by the people that want to get to that child. So for example, Lisa, if you set that sort of thing up and the assets go into a spendthrift trust for that child, and then that child later gets married and then divorced.
That's right. That IRA, that asset is not part of
they're not going to be able to get any of that.
divorce.
Same thing in a bankruptcy. Bankruptcy court would not be able to use the assets in that spendthrift trust to pay off any of those creditors or debtors. Same thing in a lawsuit. You could even have provisions that talk about who's in charge of that trust, especially if the person's under a certain age. So you might say that they can't be in charge of it until they reach, say, 25 or something like that.
Well, and you know, all these tools we're talking about on a spendthrift trust and such, you know, are very common tools, but there is a common misconception when it comes to using a tool like a trust in conjunction with an IRA. And I can't tell you how many times I have heard the rumor that you cannot have a trust as a beneficiary of an IRA. And I hear this from banking people, from financial advisors, from CPAs, and that rumor is false. You can, in fact, set up a trust to receive IRA type distributions for the benefit of a beneficiary, but you've got to dot your I's and cross your T's. It is not something that you can just fill out a form and accomplish.
Right. So, and the reason is because kind of like we were talking about earlier, the IRS wants their tax money. They want to get paid. And if you've got an IRA, you know, just like when you are alive and you take money out of it, you pay taxes. Well, when you die, the IRS wants to get paid again. They're saying, hey, look, all of this money has grown tax-free. It's time for somebody to pay the tax. Now, they do have a few provisions, and they say that if you leave it to a spouse, for example, that spouse can do what's called a spousal rollover. So the spouse is able to take that IRA and roll it over into his or her own IRA, which is, like I said, is now called a spousal IRA. Same thing when you leave behind an IRA to children. The children can roll that IRA over into what's called an inherited IRA. And if they do this correctly, then they may not have to pay all the tax at once. Instead, if you were taking money out of it, they will still have to take some money out of it, but it'll be over a much longer time frame, and therefore only small amounts each year.
So they're able to stretch the disbursements they're taking from that IRA, and so that also stretches out the tax, the time you have to pay the tax on that IRA fund. So we're going to talk about using that stretch and the ages of your children as beneficiaries of an IRA. And we're going to talk about setting up a trust and taking advantage of those rules when we come back from the break. So stick around.
As things get older, they require more care. This car and I have seen a lot of miles together, but because I take care of her, she runs just like she did in 1955. That's why I chose the Wadley Senior Clinic, with an individualized care plan designed just for me and a convenient location off Jefferson Avenue. They have everything to keep me running like new. It's not about the miles, it's about the journey. Let the Wadley Senior Clinic keep you happy, healthy, and cruising down the road of life.
Hi there, I'm Larry Sims. It's been my privilege for the past several years to be a volunteer board member of Hospice of Texarkana. And there I'm able to represent community members like you. We continually customize our end-of-life care to better meet the needs of our community. As an example, our medical director and nurse practitioner still make visits to homes and facilities. Call today to learn more about the help we can give your family. Hospice of Texarkana, the nonprofit hospice established in 1985 for the community, by the community.
Welcome back to Aging Insight. I'm John Ross, here with Lisa Scholmeyer, and you're watching the last segment of our program today where we're talking about what to do with these IRA funds that you have and how to make sure that they go to your beneficiaries, whether that's a spouse or whether that's the kids, in a way that those funds will benefit the child only or the spouse only without having to worry about it getting eaten up by things like their long-term care needs, their their creditors, the bankruptcy, lawsuits, credit card debts, even divorcing spouses. If you've got a child that just likes to get married so much, they just keep doing it over and over and over, well then we know that we're gonna need some special protections. And when it comes to IRAs, those special protections become a bit more complicated.
Yes, they do. The Internal Revenue Service has very specific rules about how you can set up an IRA into a trust and what type of trust that it can be. But John, I really think it's worth it when you consider if we don't do anything and that IRA just comes into the hands of these beneficiaries with all of their problems,
right?
Then, a lot of times that legacy, what the deceased person had worked and saved for and hoped for, poof, it just goes
right.
up.
And oftentimes that child may have a judgment against them for some old bill or something like that. And those things can stick around for years and years and years, just waiting for that person to receive something like an inheritance. And then whoop, that creditor steps in and snatches it up. So we want to make sure we protect these assets that we leave behind. But when we're talking about doing it to a trust, kind of like I was saying earlier, normally if you're leaving assets to an individual, they can roll it over and stretch out that tax burden over their life expectancy, as opposed to having to pay all that tax at one time,
Sure.
which could be significant, especially if it's a large amount. So the IRS rules say that if you don't leave it to a qualified person,
You got to pay all the tax.
then you
got to
pay all the tax at one time. But with just the right structuring, I could have a child who is a beneficiary of a trust, have the IRA go into that trust, and the trust still count as a qualified distributee or beneficiary of that IRA. In other words, the IRA is in this box that is protected. It's still there for the use, benefit, and enjoyment of my child, and yet that IRA is protected from all of these different things. And Lisa, this is all important in large part because of a big Supreme Court case about a year ago.
That's right. The U.S. Supreme Court case dealt with a situation where a lady inherited, she was the only child, she inherited an IRA from her mother. And, this IRA had about $450,000 in the IRA, so a significant inheritance. And this daughter and her husband filed for bankruptcy. And normally your retirement assets are exempt from liquidation in a bankruptcy situation, to where, if you file bankruptcy and you have an IRA in your name or a 401k, the bankruptcy court cannot reach in and get those assets to pay your creditors. Well, in this situation, the daughter said, hey, this was my mom's IRA, it's an inherited IRA, and it is also exempt from my creditors because it's a retirement type asset. And the bankruptcy court did not agree, and this case went all the way up to the Supreme Court. And John, the United States Supreme Court came back and said, hey, yeah, it was your mother's retirement asset.
Right, but it's not yours.
But it's not your retirement asset, it's an inheritance.
That's right, and as an inheritance, it was fully available to her creditors, and the bankruptcy court was able to take that inherited IRA and use it to pay off all of the daughter's creditors in that bankruptcy court. So you can't just rely on the fact that this is a retirement account, and normally retirement accounts are not subject to attack. In Texas, for example, we have very strong laws related to the protection and preservation of retirement accounts. But again, once you die and you pass that on, not a retirement account anymore, now it's an inheritance and it's fair game.
That's right. So we can set the IRA up into a trust at your death, but there's certain provisions that have to be honored such as, you know, the beneficiaries of that trust have to be living, breathing people. They have to be identifiable from, you know, the document, the trust document, and we have to make sure that that IRA is going to be paid out in some way, you know, over time.
Over some particular person's life expectancy.
Right.
You know, because that's the whole thing. These things are all tied to some person. And so when you're setting up these trusts, you have to do it very carefully. You got to have who that person is. You can't do this with a charity, for example.
Right.
You wouldn't want to mention a charity in there because that might blow the whole thing. That's not a person. But these can be very, very useful tools if they're structured correctly. And you know, I could make a pretty good argument that just about everybody's planning should contain some spendthrift type trust protections for those beneficiaries.
Yes, certainly.
And that, I mean, it almost would rise to the level of malpractice to not put it in there, because if I know you can protect your kids and I didn't help you with it, I mean, I don't know whose fault that is. Seems like it might just be my fault. So, you know, you want to really explore these things and say, yeah, even though my kids are perfectly healthy, happy, adult, financially stable, well-married individuals, that doesn't mean that's what they're going to be in the future. So you protect them. And if an IRA is one of your assets, then you're going to want to protect them with a specially designed trust to hold that IRA. That can be done. It's not as hard as it sounds, but it is very important.
But yeah, it's technical. You want to get a experienced person to help you with that.
That's right. Well, you've reached the end of another edition of Aging Insight. Once again, if you have more questions, you can always call us during our live radio show every Saturday at noon on 98.5. You can pick up a copy of the Aging Insight magazine. There's lots of good articles in there about all of these topics. Or you can just keep watching right here on Aging Insight. We'll see you next time.
Bye-bye.
Thank you for joining us for this week's Aging Insight program with John Ross and Lisa Schollmeyer. This program is made possible by
Whether you travel for business or pleasure, staying fit and healthy on the road and in the air can be easier if you consider these tips. If you'll be leaving the country, make sure you have any vaccinations or medications you may need. Before you go and during your trip, try to keep up with your exercising and vitamin supplements. Get 7 to 9 hours of sleep the night before you fly. Pack healthful snacks for the trip, such as nuts, veggies, and fruits.